Well, I think we'll get started. We're probably a little bit past time already, but welcome to our session on wetlands and development. Many of you are probably aware of wetlands regulation in the United States over a period of years, and how there's been a lot of controversy about it, and certainly a lot of consternation from landowners who have property that has included wetlands. Oftentimes the issue has just been defining what is a wetlands, and does the property really have wetlands, and then is it federally regulated? And many of them have been, and there's been a lot of back and forth about that over time, but it's been that way for some period of time. This last session of the U.S. Supreme Court, there was a decision handed down, the Saga case, which is the one we're going to talk about, which was in Idaho, which basically changed the face of how wetlands are regulated in the United States, or at least which wetlands. What's considered to be a wetlands that's federally under federal jurisdiction, and what that may mean in the future for development. We certainly have a lot of opinions both ways. Those, of course, on the property side who feel like they needed to have more ability to be able to develop property and do things more appropriately with their property. And then, of course, we have those on the environmental side who say this is critical to preserving the natural environment and the wetlands and all of the values that we get from wetlands on those. And it's the landscape has changed somewhat. So we have two great people here today that are going to be talking about this. We've got Frank Garrison, who's an attorney with the Pacific Legal Foundation. Frank will describe a little bit more of their involvement in this, but they were involved in the case that was brought against this that eventually made its way all the way to the U.S. Supreme Court and was decided upon. Frank, you're in Indiana, right?
Yep.
So he's from Indiana. And he'll be talking to us first, and then after Frank will be talking or have addressed to us Brad Cahoon. Many of you may know Brad. He's here locally. With which firm, Brad?
Denton's.
Denton's, that's right. And yeah, sorry, Brent. Whatever. I do whatever I can to get a little digs in at Brent every so often.
That's easy to do.
He makes it easy, doesn't he?
Yes, he does.
But Brad's had a lot of involvement with regard to wetlands and property issues, and how wetlands are regulated and what needs to be done. And the interesting thing is in a number of states, there is a pretty strong involvement at the state level as well with regard to wetlands. The state of Utah, and in particularly just lately, as I was we were trying to figure out who to get here to be on a panel and discuss it, one of the first things we thought was, well, we ought to get somebody from the state. What we learned as we dug around was that nobody at the state really does anything with regard to wetlands regulation. The Geologic Survey folks are involved a little bit in maybe trying to delineate and outline what wetlands are, but not even really that much. And nobody is really involved in wetlands regulation at the state level. We did extend invitations, and I guess I said I'm not going to call them out, but I guess I am going to call them out. We did extend invitations to the U.S. Army Corps of Engineers, to the Utah office, to have someone here to talk about their side or what they have seen in this. It was an interesting conversation when I finally did get a hold of someone at the Corps, and it took a while. But when I did, I got a person at their office who I think was in a managerial position, and they said, "Oh yeah, we're kind of beginning to talk about it. In fact, he was going to be going someplace to talk about it." And I said, "Well, we're going to have somebody from the Pacific Legal Foundation and Brad Cahoon there." And the response was, "Oh, I'll have to bump that up the ladder and see." And then I didn't hear for a while, and then after prodding again, the response I got back was, "Regretfully, we must decline the invitation." I thought, wow, that's interesting. So then I thought, well, how about getting somebody from an environmental organization? And I won't call out the environmental organization, but it's somebody I knew quite well and had worked with in the past. And I said, hey, we'd love to have you come to this conference and talk about what you see, maybe the impacts of this case on wetlands. Never got a response. I tried several times and did not get a response. So either they're really mad or they're licking their wounds or something, I don't know, but they really don't seem to want to talk about it. So we're going to hear from these two gentlemen, and then we can see what other viewpoints there may be out there, and we can kind of discuss where this may go in the future. So with that, Frank, let's turn it over to you.
First, I want to thank the Institute for having me today. PLF and I really appreciate the opportunity to come out in the various parts of the country, including the West, to talk about Sackett and the decision the Supreme Court handed down and the implications the decision might have for property owners going forward. So, plus I have family here in Utah in Springville, so it's always nice to be able to come back and visit them. And so it's kind of a happy bonus being able to come speak and see my family at the same time. So first I'm going to start with just a little bit of framing about the Supreme Court's decision. All 9 justices on the Supreme Court held that the Sackett's property was not waters of the United States. I think that's very important, and they all rejected the significant nexus test. So the Sacketts, who had been in a 15-year battle with the federal agencies, were vindicated by a 9-0 margin. So I think that's important to point out. And I also think it's important that the decision will be very significant for property owners. For decades, they labored under arbitrary standards and ping-ponging regulatory rules, and now they have somewhat of a clear standard going forward, and hopefully they'll be able to put their property to use without having to guess at what's illegal and what's not legal. So with that framing in mind, I'm going to give a little bit of background about the Sackett's case, a little bit about the case law and the ping-ponging regulations that occurred before the Supreme Court decided the Sackett's case last year. I'll discuss the decision in Sackett, and then briefly, Brad's going to address this a little bit more, but the implications for the states, including Utah, and a little bit about the broader impact of how the decision will frame other separation of powers issues in Washington and how those will affect states like Utah. So the Sackett's property, in 2004, the Sackett's purchased a lot in a largely built-out subdivision near Priest Lake, Idaho. At its north end, the lot was bounded by what's called the Kalispell Bay Road, a 30-foot road paved, county paved road. Immediately on the north side of the road runs a man-made ditch that drains a large complex of wetlands known as the Kalispell Fin, which is situated north of the road. The roadside ditch travels west about a half mile, where it terminates at Priest Lake itself. And immediately to the south of the Sackett's lot is a graveled road. And immediately south of that road is a row of developed houses that fronts Priest Lake. The Sackett's lot, and this is important, Sackett's lot contains no standing water, nor does the lot have any surface water connection to the ditch north of the Bay Road or the lot by Priest Lake. In 2007, the Sackett's began work on the construction of their family dream home. And in doing so, they filled in a part of the property with gravel and other materials, just so it made it for a better building pad. A few days after they did that, officials from EPA and the Army Corps entered the property and told the Sackett's work crew that the lot likely contained jurisdictional wetlands. About 6 months later, the agencies issued a compliance order asserting that the lot contained wetlands regulated as navigable waters and said the Sackett's violated the act by filling the lot without a CWA permit. The agency said substantial remediation was required or that the Sackett's could face tens of thousands of dollars a day in civil penalties. Now I want to step back and talk a little bit about the Clean Water Act and what it regulates. So it forbids the discharge of pollutants into navigable waters, and those are defined as the waters of the United States. It's backed by severe criminal and civil penalties. even negligent discharges can land you in jail. And as I said, thousands of dollars a day in civil penalties. And the jurisdictional term waters of the United States is what has sparked decades of agency rules and litigation. Since the beginning, it has been unclear what Congress meant by navigable waters and waters of the United States. And the agencies ran with that. For many years, in 1986 is when it really took off. But they started interpreting the term navigable waters basically as a virtual limitless grant of authority to regulate every surface water and wetland in the entire United States, no matter how ephemeral those wetlands might be. Basically, the act took on the character of a federal land use and zoning statute. So, the federal government was treating it basically as they could regulate almost every land use activity throughout the United States. And the upshot of that is that landowners and people trying to build houses they were required to seek a federal permit anytime one of these wetlands was located on their property. And that could be really time consuming and expensive. I believe they said that the average permit in some cases is up to $270,000 a year, and that was a study done in 2002, so that's not even in today's dollars. The act, as I mentioned, regulates the discharge of pollutants into navigable waters. It also regulates dredge and fill material, which is what was issued in the Sackett's case. These materials fix in place rock, sand, and gravel. Something as ordinary as plowing a field can be a violation. I mean, kicking up, redepositing of soil and it could be considered the discharge of a pollutant. I mean, that makes the geographic scope of what the federal government can regulate extremely important. It's from the term discharge to the term pollutant to the term point source. These are things that make people liable under the act. They've all been interpreted broadly by the federal courts since the Clean Water Act was enacted. And so, that combined with the broad interpretation of the federal government's jurisdiction to regulate certain things it has massive consequences for property owners and anybody else that's subject to the Clean Water Act. So, as soon as the Clean Water Act was passed, there was lots of litigation. The waters of the United States was first addressed in whether wetlands could be regulated in Riverside Bayview homes, and then it was, again addressed in the Swank decision by the Supreme Court, where the Supreme Court held that isolated ponds couldn't be part of the waters of the United States. But for our purposes today, Rapanos v. United States was really the first time the Supreme Court addressed directly what the waters of the United States were and what wetlands were covered under the act. The issue was the geographic scope of the federal government's authority. A majority of the Supreme Court in Rapanos struck down the EPA's boundless approach. I think it's really important to talk about what Rapanos did. It was the first time that the Supreme Court really said, hey, look, you can't regulate everything under the sun under the Clean Water Act. And so it did give some indication that there was limits on the Clean Water Act. Unfortunately, the court didn't reach a majority decision in that case. Justice Scalia authored the plurality opinion. He offered a clear standard that would limit the regulation to waters. He understood in the conventional sense of the term that waters meant relatively permanent or continuously flowing bodies of water, not puddles. And those traditional waters would be things like streams, rivers, oceans, lakes, and the like. As to wetlands, he said that the inseparably bound up with wetlands with a continuous surface water connection to one of those traditional navigable waters could be regulated. Justice Scalia noted that wetlands really aren't waters, they're wetlands, but, the Congress had included a provision that allowed some regulation of wetlands, but it tied that to the waters of the United States. So those wetlands had to be part of those traditionally navigable waters. Of course, Justice Kennedy, there was a dissent by 4 justices who basically relied on Chevron, would give deference to the EPA and the Army Corps' view. But then Justice Kennedy came up, he had a lone concurrence, where he came up with the significant nexus test. That basically said that a wetland or a damp patch of land only need vaguely define a significant nexus to downstream water. Basically, the EPA can regulate any area of the country that is damp as long as the agencies could demonstrate that the area could somehow, in some way, directly or indirectly affect downstream water. And as I said, Rapanos remains an important milestone in the CWA saga because it did say that the EPA and the Army Corps could not regulate everything. So in that respect, it was really important, even though it didn't come up with a clear rule for property owners. Returning back to the Sackets, shortly after Rapanos, the EPA, as noted, asserted the CWA's jurisdiction over the Sackets property. And it was one of the first instances under the Clean Water Act enforcement after Rapanos had been handed down. And it's important to note that we don't think there's any way that the Sackets property could have been jurisdictional under Justice Scalia's test in Rapanos, but under Justice Kennedy's significant nexus test that allowed the Army Corps and the EPA to say that their property was covered. Basically, the EPA asserted that there exists an invisible subsurface connection between the wetlands to the north of the property and their lot. And so that kicked off 16 years of litigation. The Sackets went to the Supreme Court one time before. So when the agencies issued a compliance order to the Sackets turned around and sued, trying to say that their property did not contain waters of the United States. And the district court in the Ninth Circuit said that they couldn't obtain judicial review. PLF represented them in that case, and that went all the way to the Supreme Court, and the Supreme Court said that the Sackets could sue under the APA. So that was their first victory. But after that victory, the case got remanded, and it took the district court a very long time to rule that the Sackets property was covered by the significant nexus test. The Ninth Circuit affirmed that. They agreed with Justice Kennedy's significant nexus test was the controlling rule from Rapanos, and that the Sackets property fell within that meaning. So in May of last year, the Supreme Court revisited the Sackets case again, and as I noted, a unanimous Supreme Court rejected the significant nexus test. They unanimously held that the Sackets lot is not subject to federal authority under the CWA. But there was, however, 2 principal opinions that differed on how to get there. Justice Alito, joined by Justice Roberts, Justice Thomas, Justice Gorsuch, and Justice Barrett, wrote the majority opinion. And then the main concurrence was written by Justice Kavanaugh and joined by Justice Kagan, Sotomayor, and Jackson. Justice Alito and the majority ruled for the Sackets, and in doing so, they set forth a clear standard for federal authority. It was based on Justice Scalia's standard from Rapanos. It limited regulation to waters, and how those waters and how that term is understood in the conventional sense. They are relatively permanent or continuously flowing bodies of water, like streams, rivers, oceans, lakes, and the like. something you or I could look at and say that's a water the federal government could regulate. Basically, the Supreme Court was very focused on what ordinary property owners could determine that their property was regulated under the Clean Water Act. The significant nexus test for 16 years had basically left property owners in disarray because they couldn't figure, you had to hire an expert to figure out whether your property was covered by federal jurisdiction. So the Supreme Court was very, very concerned about, coming up with a clear rule that ordinary property owners could decipher whether their property was regulated or not. As to wetlands, they recognize that wetlands are, by definition, not waters. They are wetlands, and they're presumptively outside the scope of the statute. However, the court recognized that there's a line drawing problem present when we talk about wetlands. And they recognize that some wetlands may be regulated, but only incidentally to the regulation of true waters. So those wetlands must be inseparably bound up with and contain a continuous surface connection such that an ordinary person could not tell where the water ends and where the wetlands begin. In other words, wetlands must be indistinguishable from a true waters of the United States to the naked eye. And the decision is going to have significant benefit for property owners because it provides a clear standard, and for state governments like Utah, because they're going to know, what wetlands they're going to need to step up and regulate, and it will also allow them to think about the citizens of Utah and the property owners of Utah and what the regulatory standards, how best to do that for property owners in Utah. First, there's a huge array of ordinary land use activities potentially regulated by the CWA. And so the Sackett decision gives those property owners, a clear line, as I've mentioned a few times. Second, it makes it less likely that property owners are going to be subject to huge civil penalties and even potential criminal penalties in many cases. Third, the compliance costs that property owners and developers are going to have to go through is going to be severely lessened. Mitigation requirements are going to be severely lessened. Like I said, $270,000 for the average permit, and that was in 2002 dollars. So, very, very huge benefits for property owners. And Utah, states retain their primary authority to regulate the use of land and water. The CWA makes that a primary purpose, and the Sackett opinion basically makes clear that the states are the ones that are primarily responsible for regulating wetlands. So that is going to be a huge benefit for the states. And I think I'll turn it over to Brad, and I'll save the rest for Q&A.
Not sure which clock we're working off up here. But
Yeah.
so I'm not gonna stick to these slides too much, at least early on. Frank did a great job of reviewing a lot of this, so I won't take time to review that. One thing I did want to emphasize, though, for Utah, there's really no dispute that we have two navigable waters, the Great Salt Lake and Utah Lake, and all of the tributaries, the rivers and tributaries that feed into those navigable waters. There's no dispute that those are part of the waters of the United States. And now with the Sackett opinion, as Frank's explained, all wetlands that have a continuous surface connection to those tributaries or rivers or the navigable waters themselves are part of the waters of the United States. And what I'm going to talk about a little later is how we determine wetlands that have a connection through, say, a man-made ditch or a roadside ditch that in ordinary parlance doesn't look like a stream, a river, or a lake, or an ocean, and how that would be treated. The way to think of it is, what if the Sacketts had a culvert through the 30-foot road that connected them to the roadside ditch? Would the outcome have been different? And I won't ask you, Frank, to answer that. It's not an easy answer, and that's what I'm going to talk about. So Frank reviewed, the history of why we're in this debate and why these cases have been so complicated. And the reason we care about it is because of the massive penalties. You can go to jail for a violation of the Clean Water Act. Even negligent discharges can result in criminal violations. And it's very costly, as Frank explained. Any of you that have dealt with wetlands, I'm sure you've had a wetlands consultant and had to go through that process. I happen to have consultants that help me get approvals, and then I have another set of consultants that I use as experts in litigation. And so I have to decide which ones I'm going to use depending on the circumstance. I also have a personal connection to the Sackett case. I'm licensed to practice in Idaho, and they invited me to be local counsel for them for the Sacketts. And they also used my litigation experts in that case after the Supreme Court in 2012 recognized their right to appeal the administrative compliance order. So I've had some connection and got to know Damian Schiff, who argued the 2012 case and then argued this most recent case as well. And Frank also touched on the triggers under the Clean Water Act. There are two, Section 402 and Section 404. The wetlands and discharge of dredged or fill material in the wetlands is a 404 issue. He's done a great job of already explaining the opinion. So here's what I wanted to talk about. So in January of this year, while the Sackett case was pending, the Biden administration, both the EPA and the Army Corps of Engineers, promulgated a final rule. And what they did is they basically adopted in their final rule the significant nexus test. They called it significantly affect in the final rule. And then they also adopted the continuous surface connection and said that the agencies could claim jurisdiction under either test. And then they set the rule up really so that if the Supreme Court vacated the significant nexus test, then the continuous surface connection would still be in effect. And so that's what happened, right? They knocked out the significant nexus test, significantly affect. So in September of this year, the agencies published a revised final rule, a revised definition, where they struck all of the significantly affect language and changed the language of the rule to adopt the significant, or the continuous surface connection language. And so the question is, what's the status of that revised definition? Well, there are, right now, the January final rule is enjoined, including in Utah, in 27 states. So that rule is blocked by these courts. That rule is in effect in the other states. But now the definition's been revised. So the question is, well, is the revised definition enjoined as well? And I haven't had a time or even a chance to figure out what's happening in these pending cases. My guess is that they'll likely amend their complaint, and because there's still some unresolved issues I'm going to get into that still need to be addressed in even the revised definition that's a carryover from the January promulgation. So as I said, the agencies dropped their significantly affect or significant nexus test. And that was significant because all 9 justices, as Frank explained, ruled that the Sackett's lot was not wetlands, not jurisdictional wetlands, because it had no continuous surface connection, and they refused to adopt the significant nexus link to jurisdiction. The other significant ruling in the case was the issue over the term adjacent. The agencies had adopted a very broad definition of adjacent, and that harkens back to the Bayside case from 1985, where the Supreme Court ruled that a wetland that abuts or is adjoining a navigable water is part of the waters of the United States. So what the agencies did is they adopted a rule, and it's kind of hard to see the language, but it's basically if it's in the same neighborhood, then that's jurisdictional. If it's in the same neighborhood of the jurisdictional waters, the navigable waters, then that's considered adjacent. And the interesting thing in the Sackett case is, I think, if you look at the map where the lot's located, I think some of you would be able to throw a rock and hit Priest Lake, but there's intervening lots and homes. You'd have to throw over the homes and then hit the lake. And so it technically is in the same neighborhood, and that definition, may have been a jurisdictional link, but the court rejected that and said that even to be adjacent, it has to have a continuous surface connection. And so the agencies went in and changed their definition in the September publication to make that clear. And that's a good change. That's clear. The other nice thing is, once the Sackett decision came out, the Army Corps said that we're not going to do any approved jurisdictional determinations until we figure out the case. And supposedly they're back issuing AJDs. And I've had a couple of actions since the case came down and since the September rule came out. And as I get into it, I'll explain 2 examples. So that's the good news I just talked about. There's also some bad news about where we are, and that's what I wanted to get into. So the terms relatively permanent, those terms are used, that's a carryover from the Panos decision, the Scalia opinion, plurality opinion. And in that case, he explained that in order for a wetland to be jurisdictional, there need to be a continuous surface water connection to a relatively permanent or continuous flowing body of water. And so in the September publication, the revised rule, the agencies did not define what relatively permanent means. And they also didn't define what continuously flowing means. Those are all missing. And the other important part of this is when Justice Scalia was explaining this concept of waters, he explained that those waters are only those relatively permanent standing or continuously flowing bodies of water forming geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes. And then the other concept is what Frank explained, is the waters have to be indistinguishable from the navigable waters, the traditional navigable waters, such. such that it's difficult to determine where the water begins and ends. or it's not difficult. And then the other thing I wanted to point out is states are delegated authority to regulate wetlands under the Clean Water Act, and many states have their own much broader definitions of wetlands. In the state of Utah, that's not the case. As we'll explain, the state doesn't directly regulate wetlands. The definition of waters of the state does not include wetlands in the same context of Dresden fill permitting. Okay, so let's talk about, again, these are the categories of jurisdictional waters. There's traditional navigable waters, Great Salt Lake, Utah Lake, territorial seas, they don't apply in Utah. Interstate waters, a river that's interstate, impoundments that have, and again, the key point there is those still have to have a continuous surface connection. Tributaries, we mentioned that. Adjacent wetlands, those are now defined. Interstate lakes and ponds. The agencies in their rule did not specifically define even tributaries, but they do allude to the language that are relatively permanent, standing, or continuously flowing bodies of water. But again, those terms are undefined, even for a tributary. And then we've already talked, Frank's done a great job of reviewing what adjacent wetlands are. If they have a continuous surface connection to a relatively permanent water body, those are also jurisdictional. So here's where it gets a little hairy. So the January rule has a definition of ditches, and in the redefinition in September, they didn't change the definition of ditches. And so this is interesting because it says that the following are not waters of the United States. And this is all directly from the rule itself. There's a EPA and the Corps published a red line of the rule, which is kind of nice to see what exact changes they made. So ditches, the way they've defined it, those ditches are not part of the waters of the United States, including roadside ditches, excavated wholly in and draining only dry land and that do not carry a relatively permanent flow of water. So that raises the question, if you have a roadside ditch that is carrying a relatively permanent flow of water, is that a ditch under this definition? I think the agencies are going to argue no, because if it has a relatively permanent flow of water, it's not part of the definition of ditch, and it has the continuous surface connection to make it part of the waters of the United States. The problem with that is this definition doesn't reflect the full definition from the Scalia opinion that in ordinary parlance, it's water bodies that look more like streams, rivers, lakes, and oceans. They're not man-made. And so that's where the big issue is going to be in the future, is if a man-made ditch doesn't look like a stream, but it has a relatively permanent flow, is that sufficient connection?
It seems like it does raise the question of if you have a ditch that will, man-made, that will catch stormwater, that runs that stormwater straight into an actual body of water, that doesn't actually, it's not carrying a relatively permanent flow because it just rains every so often in St. George, for example, that clearly would add pollutants to the body of water, but it doesn't mean, but it falls within the definition of ditches, so now no longer can be regulated, right?
Right, yeah, that's what I'd argue, yeah, good point. Okay, so here's what's interesting. So in the January preamble, again, this is the rule that was promulgated while SACIT was pending. There's language in the preamble talking about relatively permanent. It's not in that CFR regulation. It's just in the discussion in the Federal Register about their interpretations, right? So this is really, really important. So one of the concepts that Scalia discussed is, would a stream that's only has intermittent flow, only responds to stormwater, would that be sufficient? And he said no. How about an ephemeral or a perennial? Well, certainly a perennial. I don't think there's any question about that. If it's a perennial stream, that's in. If it's ephemeral, I think that's arguable. If it's intermittent, under Scalia's thinking, that's out for sure. And so the ephemeral is kind of, we're not really sure. So it's interesting because back when, after the Rapanos decision came down in 2006, the agencies promulgated guidance in 2007. That was right at the end of the second Bush administration. And then in 2008, the Obama administration published an updated Rapanos guidance. And in that guidance, they adopted the 90-day rule for relatively permanent. So if you have a stream or even a ditch that's flowing less than 90 days, that's not a connection. That's not a jurisdictional connection. If it's beyond 90 days, it is. But at least you had a bright line test, right? So the agencies here said, hey, we're not going to look at any specific time period because regionally around the United States, things are acting differently, right? And we have to look at other things besides just duration.
What about canals, like for irrigation canals? They run more than 3 months?
Yeah, we have canals like the Weber Provo Canal, right?
Or
It's
anything,
nonstop, right?
Weber, Case Creek, I mean.
Yeah, there's plenty of them, right? And so the question is, okay, if it's man-made, would it still fit? I mean, the agencies, one of the things when the agencies promulgated the January rule, they don't talk about man-made at all. They don't mention that. And they don't talk about natural water bodies either. So it's kind of just open. And it's arguable, I think. So a canal from an aerial photo might look like a stream or a river, at least some stretch of it, right? And so you might have an argument. But there might be other canals that just look like a man-made ditch. And so you'd have an argument that that's not in ordinary parlance a stream or a river, right? Okay, so I wanted to bring this up. So this is an example of what we're talking about. So on this slide, there's a red area that's delineated. We'll assume it's delineated wetland. It has all three indicators. It has wetland plants, hydric soils, and wetland hydrology. And it's hard to see on this, but at the bottom, in kind of that darker area, that's actually a ditch. It's a drainage ditch. It's not an irrigation ditch. This is back east. And so that ditch responds to snowmelt and to storm events. Okay, so water hits, and by the way, this is a farmed acreage historically, and it also this also raised prior converted cropland. We're not going to get into that, but so you can see in the image that there are these culverts. There's 3 of them. Right? Well, this shows 2 of them. I think there's actually 3 of them, and this road's about 60 feet wide. It's a bigger road, and then that light blue area, that is a roadside ditch. And the interesting thing is it's receiving drainage from a lot of properties up gradient. And it has a relatively permanent flow. I mean, it's flowing pretty much year round, except when it's frozen in the winter. And so this is the dilemma. We're talking about a relatively permanent, continuous flowing body of water, but also a surface water connection. So immediately when I think of any piping, it immediately raises the question, well, does that now make it underground? It's not surface. And so that's an open question that hasn't been answered. And there's arguments both ways, right? So this is really interesting. So let me show you the next image. Okay, so this will give away where we are if you know the eastern United States. Mark, you probably know where this is. So you can see the farm, and the roadside ditch goes all the way down to Ransom Creek, and then that's clearly, when we look at this image, there are two features that in ordinary parlance look like streams and rivers, right? No question about it. And so there's no debate that Ransom Creek and Tonawanda Creek are part of the waters of the United States. And by the way, they drain, and this all drains ultimately into the Atlantic Ocean. That's the drainage. So the question is because of that culvert, does that change the equation? Does it change the outcome? Because that arguably makes a connection to the wetlands and to these ditches, but the ditches that are draining this wetland are only responding to rainfall and snowmelt. And so is that sufficient to make the drainage ditch, just looking at the drainage ditch alone, is that sufficient to meet the relatively permanent, continuously flowing test? And then the next link is, well, if it does, then is the roadside ditch, in ordinary parlance, a stream or a river with relatively permanent flow? It has relatively permanent flow, but does that meet the test? Is a man-made ditch sufficient to make the linkage? And going back to the definition we talked about, the Army Corps' current definition, it's in effect, it's enjoined in 27 states, including Utah, I think, or that's up in the air. Certainly in the other states, that definition is in effect. And if there's a ditch, any ditch, even a roadside ditch, man-made ditch, that has a relatively permanent flow, what are the agencies going to do? I think they're going to invoke that rule, that definition of ditch, to say that's not a ditch. And so in my opinion, that's the next battleground for debate. And that's what we're going to litigate the next, I don't know. I could be wrong, but I don't think I am. This is why I don't think I'm wrong. So we've had two matters, both in Utah, and both since the Saget case came down in May, where one case had clearly a wetland, but it was connected to a ditch that was culverted, went under I-15 and ended up in the Great Salt Lake. And the outcome on that one was that wetland is not jurisdictional because that connection is not a natural stream connection. And then we had another case where it was similar to this one, but on that one it was an irrigated field, but part of the field was so wet that it qualified as a wetland. And there was actually a ditch similar to this that drained excess irrigation water, and then that ditch connected to a tributary that's clearly a tributary, and then that drained into a river, and that river ends up in the Great Salt Lake. In that case, the decision was that ditch is relatively permanent. And we disagree that it's just a man-made ditch and it's not jurisdictional. And so in two examples, very similar, but two different outcomes. And I think that's what we're up against in the future. So, any questions? I don't know how we're doing on time.
We got about 10 minutes.
Okay. So throw me out a hypothetical or something.
Brad, I think a lot of people thought, you know, when they heard about this decision by the court on Sackett, they thought, oh, great, we've now resolved the wetlands issue. And there's gonna be a lot of properties now that are gonna clearly be able to be developed that couldn't be developed before. But what you guys are describing, it doesn't sound like that's really the case.
Yeah, I mean, like Frank said, and I've said, there is more clarity now. But there's still some lingering issues.
Yeah.
Particularly any man-made type ditch connection, that's where we're gonna have a battleground. And there's a lot of those in the state, right?
Yeah.
Yeah.
I just want to add a couple of things. So there's some notice and comment problems with the Biden's revision of the rule that may play out to have the rule vacated. They're going to have to go back to the drawing board. But more importantly, this is one, I was running a little bit long. So the separation of powers issues in Sackett that the court addressed, when they talked about due process issues, clear statement rules based in due process and federalism, I think that's going to have an effect on, the issues that we're talking about now that Brad talked about. Anything that the agency does is going to have to be within the bounds of the statute, and it's going to have to be clearly so. So I think by the court putting that making clear that when you have a statute like the Clean Water Act that carries civil and criminal penalties, that the agencies need to rely on clear language. That's going to affect how these issues going forward play out.
So they need to be clear in their language.
If they're coming in through an enforcement action, or when they, go back to the drawing board, hopefully, and try and implement the Sackett rules into a new rulemaking, they're going to be very, very careful, because courts have now been instructed you need to apply a clear statement rule, and if there's ambiguities in what's going on, you need to construe it in favor of the property owners or the state's ability to control their jurisdiction, their traditional police powers over water and land use, and the due process problem. You need to be able to make sure you have a clear rule that gives people fair notice that what they're doing is either going to be covered or not covered by the act. And, so I think that's going to inform anything going forward.
Well, and that's interesting, because we do have a couple of court cases, and then the legislature adopted some language a couple of years ago that basically says, if you don't have a clear rule, then you have to decide in favor of the property owner. And it sounds like maybe you're getting to some.
Yeah, and the Supreme Court may well overrule Chevron deference this term in a case called Loper Bright. But even if not, when it comes to statutes like the Clean Water Act that carry both of these civil and criminal penalties, I think broad deference is just, it's just gone when it comes to stuff like the Clean Water Act.
Yeah.
So agencies are going to have to be very
Somebody had a
careful going
question.
forward.
Saw hands.
I have a scenario. I have a good one.
Okay.
So we have a property owner who has for decades, they have agricultural canals off of the Loop River that go right onto their property for agricultural use. When naturally that water would probably have just flown into the Salt Lake. So, interpretation of that one.
So are
And
the,
then I have a caveat, and it deals with House Bill 349.
and what, are the lands around the canals, are they wetlands? Have they been delineated wetlands? Well, let's assume they're wetlands.
Let's assume they're wetlands. If they have, it hasn't been, yeah.
We haven't had any delineation reports done because it's undeveloped, it's all ag land. It's
Okay.
been-
Well, let's assume they're wetlands and they're connected to these
And they
drainage canal,
If you looked on the
and
map,
they're connected to the Great Salt Lake, right? So that's the very issue. And those are man-made, right? Man-made ditches, or?
Yes,
Yeah.
yes, yes.
So that is the issue. And I assume they have relatively permanent flow. They're flowing all the time, it sounds like. So the Army Corps, I think, and the EPA would take the position, they don't meet our definition of ditches because they have relatively permanent flow.
So this particular.
And so the landowner would have to argue, well, wait a minute, these are man-made. In ordinary parlance, these don't look like a stream or a river.
They're also used as secondary water, the secondary water that's in those ditches is retail.
Is what?
The landowner retails it.
Oh, I see.
Oh, he
So they're
sells it.
selling, yeah.
Hmm.
Yeah, so there's water rights, yeah.
So is there a domino effect from this that could affect claims to water rights?
Well, so a water user has a right to divert water. That's recognized. And so there is some overlap with the state in jurisdiction over surface waters, natural streams. So in order for someone to alter the bed or bank of a natural stream, they have to get a stream alteration permit, okay? And there's exceptions to that. And so the state engineer is under a general permit with the Army Corps of Engineers to administer stream alteration permits for natural stream alterations. And so a water user already has an existing right to divert from natural streams, right? And they also have a right, and there's exceptions too that allow water users to divert without permits. So you have to get into those regulations to make sure, am I in or am I out for a permit requirement? Yeah.
Other question?
That's okay, I'll do it offline, because it's.
Okay. Anybody else? Any other questions? Yeah, Dave.
Got a client up in northern Utah. It's the classic example where you've got about 5 acres of ground. There's a couple of ponds on the ground. They've been there for a long time. They collect water in the spring, they evaporate in the fall, when the heat just evaporates them. In dry years, they're dry all year. But they've grown up some grasses and some other things that make them look like wetlands, but they don't flow anywhere. And they don't have any flow into them other than off of the field. It's just drainage ponds to drain the field. Probably originally man created by the farmer that originally homesteaded, just to drain his field. But they don't go anywhere. Is that impacted by this?
And they don't have any continuous surface connection
There's no
to
surface
a,
connection. They just sit
yeah.
there in the field until they evaporate, and then the farmer cuts them as wild grass late in the fall.
Yeah, so the case that Frank talked about from 2001 was the Swank case. That was an isolated pond case. It was abandoned gravel pit ponds that had no continuous surface connection, and those were held not to be jurisdictional waters of the United States because of their isolation.
Subject to some state regulations with regard to dredging and whatnot. Maybe not in Utah. Some states have.
Maybe, you'd have to maybe look to see if there's some permit or local permit you would need to dredge a pond like that.
In this particular instance, they would like to fill the pond because they've gone from flood irrigation where they needed those retention ponds to
Mhm.
sprinkle irrigation where they don't want it.
Yeah. All right, we are out of time.
All right.
Thanks for your participation. Thanks to our panelists.
Nice
We
to
have
meet
a
you,
10-minute
Frank. Good
break
job.
until the next.